Hey everyone, welcome back. Thank you for joining us today. Today we have attorney Jonathan Steele with us, and we're going to be talking about some cool things. He's going to give us some insight and share some of his experience with us. It is an honor and a pleasure to have him on here. So thank you, Jonathan, for being on the podcast with me. I appreciate your time.
It's a pleasure to be with you. Thanks for having me.
Absolutely, absolutely. So what we're going to do is, Jonathan, if you don't mind, I'd like to go ahead and give everybody a formal introduction, as far as who you are. You're very ambitious, have accomplished quite a bit in your career, and I'd love to be able to have people just know who you are. So let's go ahead and start by, so you're an attorney right now, a practicing attorney in the state of Illinois. You're currently a partner at Bierman LLP. You have a law degree from the John Marshall Law School. As an attorney, right, you specialize in family law, digital privacy, and cybersecurity, and the intersection of these, right, which is fascinating and it is very valuable. And through this specialized knowledge, you're able to prioritize and ensure the privacy and security of your clients by integrating kind of cutting edge, right, digital protection strategies, which is fascinating, right? That's such an important issue nowadays. You also own and operate Steele Fortress, and this is where you leverage your unique blend of legal and cybersecurity expertise to provide comprehensive cybersecurity and privacy consulting services, right, for individuals and companies. You've also been recognized as a rising star by the Illinois Super Lawyers magazine, and this is a distinction, right? This is very important, a distinction that's reserved for less than 2.5% of attorneys under the age of 40 in the state of Illinois. And you've also been recognized as an emerging lawyer by Leading Lawyers magazine. And that's an honor that's given to fewer than 2% of Illinois attorneys each year. You've also served on the board of the Medical Research Junior Board Foundation at the Children's Hospital there in Chicago. So that's awesome. You've accomplished some great things, like I said, and this is going to be an exciting conversation. It's going to be an interesting conversation. I'm looking forward to your perspective on some of the questions that I prepared for you. So without further ado, let's go ahead and get started. I'd like to have everybody kind of get to know who you are as a person. So if you don't mind, let's get started with, can you tell us, where did you grow up? I mean, where are you originally from? We can start there.
Born and raised in Chicago. I went to school in Indiana, but other than that, I've been in Chicago my whole life.
Nice. And what led you to become an attorney? At what point, at what age did you make that decision?
About as early as I could talk and argue is when I knew I wanted to become an attorney, following in my grandfather's footsteps. And then I started clerking at the age of 16 and have just sort of latched on to boss that I worked with at that age and have continued on with him since then.
Nice. Was there something specific that happened to you in your life, maybe early on that led to that decision, or was it just your passion for, or your maybe passion, or how much you love, being able to argue your point, or what was it that got you to? Was there a turning point, a pivotal moment where you decided this is what I got to do?
I've always liked to argue. I honed that skill on my sister at a young age, and so. It was clear to me at a very early age that this was my passion and where I belonged.
Nice, nice. And then, just out of curiosity, had we known you, right, back when you were in high school, can you describe to us what you were like back in high school? I think those are formative years, and it's always interesting to know what people were like during those years.
Pretty similar. I might have been a little bit thinner then than I am now, but I was as argumentative, I was as talkative with the people that I was close to, and as quiet with the people that I wasn't close to as I am now. So pretty much the same person, just a little bit more gray on my hair, and yeah.
Cool. Now we talked about some of your accomplishments, and you're obviously very driven. What would you say that you're running from, or what is it that you're chasing in life? What's your jet fuel?
Success, right? So, I want to build up my practice as much as I can. I want to provide for my two kids as best I can, and for my wife and my family. And so I think providing for the family is probably the number one driving jet fuel at the moment. and attaining the next level of partnership is always important to me.
Nice, nice. And how long have you been a partner there at Bierman LLP?
It's been about 5 or 6 years now.
Nice.
Yeah.
That's cool. Were there any turning points in your life? I always, think it's interesting to hear about these, right? If there were any turning points, maybe moments of failure, right? If loosely, defined, or moments of maybe something that happened that there were turning points in your life, right? That led you to become the man that you are today.
I think having kids was an important turning point. It certainly adds a level of depth and understanding to the family law practice. It adds higher stakes to what it is that we do for clients, and shaped, who I'm going to be going forward. So I would say, 5 years ago when my oldest was born was a turning point for me.
That's awesome. That's cool. So jumping now to your actual, like you do, right, as far as work, what types of cases within family law are you most passionate about, and find most fulfilling?
We do the full gamut. We do divorce and paternity and orders of protection, stalking orders. For whatever reason, I've fallen into a niche of litigation or trying cases, and I've tried a lot of orders of protection cases in my career. And for some reason, when we get orders of protection, those fall on my desk pretty often. So I like those. They can be high stakes. And every case is different. So I would say orders of protection.
Okay, cool. And if you could share with us, what are some of the misconceptions that people have maybe about family law and your area of practice, and maybe, some of these protective orders, right? What are some of the misconceptions that people have that maybe you could share with us?
I would say one of them is that, if your spouse hires a good lawyer, you're in trouble. It's the opposite. I think when your spouse hires a good lawyer, then we're on common ground. We share the same books. We have a similar understanding of how the case will shake out. And so we can usually negotiate a settlement faster and less expensive than if your spouse hires a lawyer that doesn't know anything about the law. Then they need to learn on the job on your dime. And so it's a pretty common misconception for somebody to worry when there's a good lawyer on the other side. So that's one. And then I think another is that, if you're a father in a divorce or in a paternity case, that the mother of your child has a leg up simply by virtue of being the mother in terms of, custody or decision making or parenting time. And that's just not the case anymore. It was at some point, but the laws have changed. And so now you're on equal footing, and there's a presumption that it's best for a child to spend equal time with both parents.
That's this. I would like to also ask you a question about what you said a minute ago, but this last point that you just made, do you think that's across the board nationwide, or is that just in Illinois?
I can't speak to the nation as a whole. I do know specifically a number of states have moved in that direction, and frankly, I think it's the right direction. There was something that was either embraced by custom or by name specifically not too long ago. It was known as the tender years doctrine, which basically held that, a child is better served with mom, at least at a young age. And now, the law has changed, and it welcomes dads being a part of their child's life as much as moms. It took two parents to bring a child into the world, and it takes two parents to raise the child. And you can be the best mom in the world, but you can't be a good dad, and vice versa.
Yeah, I agree with that completely. Yeah, that's good to hear that. I actually did not know that there had been some major changes in at least some of the states, right? Because obviously that's devastating for a lot of men, right? Because the laws were favoring women, and you pointed out one of these doctrines, and but it's good to see that that's changing. So, and you said that's in the last 10 years or so.
Yeah, it's maybe even more recent than that, but it's been a slow progression in that direction. And in the last few years, we've really solidified it in Illinois. Now there's a presumption that the child's best interests are served with equal time with both parents. And so to move the court off of that presumption, you need a pretty good reason about why mom should have more time.
That's cool. And then the other point you made, right? The other misconception that you talked about people commonly have, right? Where they're worried when somebody else has, when their spouse hires a quality attorney, it makes complete sense, but it's so counterintuitive, right? Because you would think if they hired the best attorney in the state or the county, that you're in trouble, right? That they're gonna, but if as long as I guess the statement you made, is that contingent upon you also hiring a quality attorney that's able to negotiate with another quality attorney? Um,
Yeah, the misconception is from my clients. I think if your own attorney doesn't know what they're doing and your opposing party hired a good attorney, then you may be in trouble. But if you have a good attorney and your opposing party hires a good attorney, you're in good hands. You're not in bad shape. You're not in danger. If anything, it's going to expedite the process. It's going to make it less expensive. And you're going to get to the same outcome without having to spend as long as years in the court process.
would it be accurate to say that the part of the reason for that is because uh, if you're a top attorney and you're going up against another top attorney, then you guys almost like play this like a game of chess, right? You don't have to actually, like you said, if it's an inexperienced attorney, he's swinging for the fences and he's trying every single way that he can to try to get an advantage on you. But if you're more experienced and seasoned and you understand what you're doing, then you're able to play this like a game of chess, both of you guys, right? And you're able to see that at the end, the outcome it has to be inevitably be this or that, and there's no reason to waste time filing unnecessary pleadings and so forth.
If I'm litigating against someone that's not familiar with family law or a rookie, I'm playing chess and they're playing checkers. It's just a totally different game, and they don't understand the law. They don't understand the rules that are governing this proceeding. And so they're having to learn along the way, and my client is having to pay me to teach them the law along the way. If I'm litigating against another good lawyer, that's not the case. We're playing chess together. I probably tried cases against that lawyer in the past, and so there's a mutual respect. They understand that if push comes to shove, uh, we know what we're doing. I know what I'm doing, and so there's no need to test each other. We have a shared understanding of what the law provides as far as an outcome goes, and assuming we can put our client's interests first, which we normally do, or always, then we arrive at that outcome by way of settlement and don't have to waste a ton of time and a ton of money getting there by way of force through a court process.
Sure, sure. Cool. If you don't mind, I'd love to jump into maybe some of the challenges right within the system. We've kind of touched on that a bit, but I'd love to talk about maybe some of the challenges as far as maybe and we could start real broad, right? Kind of and you can direct the conversation there as far as how you'd like to approach this, but maybe quote unquote inequalities or disadvantages or advantages that exist for either party within the criminal justice within the system, right? The family law system. And I know we've already touched on it a little bit, but I'd love to be able to kind of dive into that just a little bit deeper. Maybe there currently still are some inequalities, right, for husbands or for wives. I'd love to just get your take on that. What's your opinion on that?
In the realm of an order protection, there still exists some inequality. And what I mean by that is to get an order protection in the state of Illinois, you can go in on an emergency basis and you're going in by yourself. There's no opposing party. It's called an ex parte proceeding. And it's just you, maybe your lawyer and the judge, and you get to tell one side of the story. That's all the judge hears when they decide, am I going to grant an emergency order protection? And there's a tendency to give those out like candy because judges are fearful that if they deny an order protection, and then something bad happens, like somebody gets hurt after having denied an order of protection, then that judge is all over the front page of the paper. So they err on the side of caution and they grant an emergency order, which can be anywhere from 14 to 21 days in duration. And in practice, they end up getting extended over and over and over again, particularly in the Zoom age, when the courts were fumbling through the process and we're still trying to catch up on like old dockets. Um, you may be ready as the respondent or the defendant to have your case heard, and you may be months and months down the road. Meanwhile, this order protection is in place. It may have booted you from your home. It would have resulted in the revocation of a FOID card, and it prejudices you greatly. A lot of jobs are in jeopardy if you are the respondent in an order of protection case. And then a lot of divorce cases start out with an order of protection. So if mom runs to the courthouse and gets an emergency order of protection and then the next day files for divorce, you're starting out in a hole. You're starting out disadvantaged, and it's unfair because you didn't even have your day in court. You didn't even have the opportunity to say anything, and you're prejudiced right off the bat. And a lot of lawyers and a lot of parties end up using the Domestic Violence Act or orders of protection as a sword rather than as a shield to start a case off in this way. And it's unethical and it's a misuse of the system, and it it does prejudice the rights of the respondent, and it prejudices the rights of parents. And it's unjust. And courts they're getting a little bit more cognizant, at least the divorce courts, of motive when you start a case off that way, and it can come to bite you at the end. But that could be a year plus down the road before the situation is rectified.
Yeah. So that's interesting. I'd love to have you elaborate a little bit on some of these prejudices because, that's a legal term, right? And not everybody understands exactly what that means. And I'd love to get some examples of how you think that by somebody following this strategy, right, that you just explained, in addition to, right, and you did mention, you alluded to that it could, their jobs could be on the line, right? Because there are certain types of jobs where if an ex parte, a protective order is filed, some of the ramifications could include them getting fired from their job or being suspended or something to that effect. And that just, right, turns somebody's life completely upside down. But as far as the court proceedings during a divorce, like what is, you said they start off in the hole. Can you give us just a handful of examples of how, of what that means?
Sure. If you look at a case of a police officer and the wife of that police officer starts a case off, she runs to domestic violence court and she says, "I'm afraid of my husband." Whether that fear is genuine or not, and the judge being inclined to grant these orders so that they don't end up on the front page of the paper, may enter a 21-day order of protection, figuring, at the end of that, the respondent will have their day in court and no harm, no foul. Meanwhile, the police officer is going to get suspended from active duty or active service because they can't hold a gun, because they can't be the respondent in an order of protection case. Maybe they're not getting paid. Maybe their gun's being revoked. Maybe they're getting kicked out of their home. And so now they're scrambling to try to find temporary housing. If they are the parent of a child, now they're trying to establish some sort of emergency temporary parenting schedule, which parenting time is almost never an emergency. So that dad could go months without seeing his child before he even has an opportunity to have a hearing. And then mom can game the system a little bit. She can ask to appoint a guardian ad litem or a child representative and try to slow down the process as much as she can. And then you got a divorce judge that's saying, right now there's an order of protection in place. I can't just remove it without a hearing. So I'll give you a hearing, but it's going to be months down the road. And I want a guardian to investigate. And, we'll get to parenting time when we get to parenting time. And so by the time this all shakes out, this could be 5 months down the road before dad has opened his mouth to say, none of this is true. Meanwhile, he's out his job. He's not earning. He's out of his house. He's trying to find somewhere that he can stay on a temporary basis, and he's not seeing his child. So he's just getting hit from every direction without the court ever having an opportunity to hear both sides of the story. And I think anytime you're ruling based on one side of the story, you're doing an injustice to both of the parties. So I understand why courts are inclined to err on the side of caution, but I'm always against erring at all. I think that if you're granting an emergency order protection, you really should have a full hearing right when it expires at the 14 or 21 day mark, and be very reluctant to grant any continuances or extend it at all unless there's an agreement, because the respondent has a right to be heard. They shouldn't be out of a job. They shouldn't be out of income. They shouldn't be without their home or their children just because mom gamed the system to gain an advantage right off the bat.
That's a great solution. What do you think, what would it take to be able to implement that and make that a hard, fast rule where the respondent would have to be given an opportunity to be heard within, 15 to 21 days?
The judges would just have to start following the law. That already is the law. The law provides that continuances are to be rarely granted for this reason. And the law allows dad in that situation to come in on an emergency motion to rehear the order protection and argue that it should never have been granted. But judges, for whatever reason, at least in Chicago, they say, sure, you have a right to come in and ask to rehear it, but that doesn't mean I need to rehear it right now. I'll give you a date in 4 or 5 months. And they understand that continuances technically are to be rarely granted, and yet they're granting them all the time. And it's because their dockets are swamped. Every morning they have 40 or 50 cases up, and they just don't have time or bandwidth to have every case heard when they should be heard. And it's unfair to all of the people in the system because it's not their fault that the system is stressed.
Do you think one possible solution to that, and I know that it's complicated, right? But do you think one possible solution to that would be for there to be just simply more judges, right? So that they don't have 40 cases on their docket first thing in the morning. Maybe they have 15 or 20, which would be a marginally, right? It would be a very minimal cost, additional cost to a county. Just as an example here where I'm at in Provo, they just built a big giant courthouse that had to have cost them a couple $100 million or more. Huge, I mean, massive, beautiful, right? And you think, well, if you could spend a couple $100 million on a courthouse like that, to be able to allocate an extra 150,000 for a couple more judges, right? 150,000 each or whatever it is that they made. It's really not that much more to be able to ensure that justice takes place, that people like, that if we're using the example that we were just discussing, that you don't have, men that are being fired from their jobs, losing, right, their home, their children, all that without even being heard. Seems to me like if we look at the cost benefit analysis, it favors spending an extra few $100,000 a year for more judges. But is that a solution, or is that just too simplistic?
It could be. It's going to depend on what county you're in, whether or not that's going to solve the problem. But it's gonna lessen the load on each judge with every judge you add into the mix. So it would help to expedite things. Sorry about that. So it would certainly help because it would lessen the load on each individual judge if you have more resources available. But whether or not it's a complete solution is going to depend on just the full caseload. Cook County, there's some divorce judges that have 4,000 cases actively on their docket, and that's just unmanageable.
Right. What about one other thing you mentioned is that there's this pressure on judges to grant these ex parte communications, right? Because they don't want to be on the cover of the newspaper right the next morning if things were to go south, right, and somebody ends up being hurt, which is a legitimate concern for them. but at the same time, right, it leads to some bad decisions, right, and it leads to all sorts of the ripple effect, right? Whenever somebody is gaming the system, is could be devastating for some men, right? And potentially some women. I mean, I'm sure it happens on the other side, maybe not as often, but I'm sure it happens as well. But what do you think is the solution to that? Because that one's a little bit tougher, right? Because sometimes they're elected, right? Sometimes, so they need to be able to have protect their reputation.
You know, the reason it happens is for a reason. It has happened where judges have said no, and then someone has been killed, and it does end up on the front page, and no judge wants to be that person. I think a potential solution is to have harsh penalties for bringing a petition for order protection that has no merit. And that's going to discourage people from trying to game the system, because if, for instance, you have to pay all of the respondents' attorney's fees for having to defend themselves because it's found at the end of an actual full hearing that you had no basis to bring this and you were gaming the system, it's going to discourage people from doing that. And then, you know, you don't have to put the judge in that position of turning down meritorious orders of protection, because they are often heard for good reason. They are often granted for good reason. It's not always that somebody's just gaming the system, but it does happen. And I think, you know, the law provides currently that if the respondent can prove that the petitioner made an untrue statement, then they can get attorney's fees. The problem with that is, in my example with the mom and the police officer, mom could take that case all the way up until the day of trial 6 months later and then say, I'm just going to withdraw my petition. I don't want to move forward on it. I don't want to incur the time or the money. And so dad sort of wins there because the order of protection's gone. But in order to have a finding that her statements were untrue, he then needs to put the full trial on anyway. And so he's faced with, do I put on a trial knowing that the stakes are nothing because she withdrew it? And so now I'm going to spend, I don't know, $10,000 on a trial just to sort of clear my name when she's already withdrawn it. So in that situation, it often just doesn't even make sense to try to press for a finding that there were untrue statements. So I think that's sort of a half measure to say you need to prove untrue statements in order to get some attorney's fees back. I think it should be more just, if at any time the court finds that you were a little flimsy on the facts and you were probably just doing this to gain a leg up, so I'm going to make you responsible for all of the attorney's fees that have been incurred here. I think that's going to serve as a pretty big deterrent to people to try to use this strategy.
How likely or how difficult or easy do you think it would be to implement that?
It would be easy to implement. It's just a question of, you know, what is the mechanism, right? So there's already some mechanisms in place for sanctioning lawyers and for sanctioning parties for taking frivolous positions that are not well grounded in law. But courts are reluctant to issue sanctions. They're, you know, you really have to be egregious in what you're doing for a court to go that route. And again, that goes back to them being overloaded. They don't always have time to give you a full hearing on a request for sanctions. And so that, you know, they try to protect lawyers, number one, but they should not be as reluctant to issue sanctions against parties if they're just gaming the system. Sometimes it's really clear on its face that there was no merit at any point in this, and all you were doing was trying to get a leg up and kick dad out of the house and keep him from seeing his child for a period of time, so that when the court is awarding parenting time, one of the considerations is, well, status quo. The child's been with mom for months at this point. I don't want to, you know, upset the apple cart and shift this all over to dad because it'll be hard on the child. But none of that should have happened in the first place.
Right, right. That makes complete sense. Yeah. How often would you say you see this scenario as a percentage, right? Maybe in your career or whatever metric you want to use. I'm curious to know in your profession, right? as somebody that specializes in this area of the law, how often do you see, and when I say this, what I'm referring to is one individual gaming the system, and gaming in the true sense, right? That the allegations were false and they're just looking to try to get a leg up on the other person, whether it's financially or, custody of children and so forth.
It's an alarmingly high occurrence. It's frequent. It's hard to give an exact percentage, but a lot of the orders of protection I see should not have been granted. They're real light on the facts. They're real light on abuse, which is really what you need to prove to get an order of protection. Some of it's just dirty looks. Some of it's, calling somebody a bad name. And judges grant them. If I had to give a percentage, I would say at least maybe a third of divorce cases have an order of protection at some point that had no business being entered at any time.
Wow. Wow. And do you practice criminal law at all as far as domestic violence? Do you do much of that?
Earlier in my career, I did a little bit more than I currently do. If there is a domestic battery that arises out of one of my current cases, then I will sometimes take that on. If it's just a new case of domestic battery and there's no connection to like a divorce case or paternity case, I'll usually refer those out.
The reason I ask is, and I know you said you don't, right? You just explained like there's some nuanced situations where you will take them on, but I'm just curious to know, right? It's not your main area of focus, right, in your profession, but what's your take on the, and this is a tough question, right? But people get convicted of domestic violence all the time, right? Right, domestic, and there's different names for it. You talked about battery, and I'm just curious to know your opinion, right? What percentage of those cases, and if you can give a percentage, or maybe just your opinion on this, do you think where, we're talking about people that game the system for, non-criminal type outcomes, but then there's also outcomes that are criminal, right? I mean, if it's like you mentioned battery, but what percentage of those cases, or what's been your experience with people that maybe game the system to get criminal charges put on their spouse? Can you speak to it just a bit? I mean, you can take whatever approach you want. I know it's a tough, a tough question, but love to get your insight on that.
It's hard as a like an overall percentage to give that, but I can tell you from the number of domestic violence cases I've defended, at least with the Cook County State's Attorney's Office, if you bring them up until the brink of trial, a lot of times they withdraw their case on the day of trial because they recognize they don't have the facts. They recognize this is a shaky fact pattern. I'm going to lose if I try this case. And the problem is you have to push them up until the brink of trial before they'll make that determination. And so that's costly for a party. And so it's basically saying to people, if you can afford a lawyer and you can afford an aggressive lawyer that's not willing to back down, that's willing to go to trial, your case goes away. But if you don't have that luxury, if you don't have the money, if you have a public defender, if you want to try to represent yourself, or you want a lawyer that maybe isn't very experienced and is all you can afford, you may end up with a conviction. You may end up with having to take a guilty plea, whether you did it or not, just because you don't have the resources to fight it. So there's an inherent injustice there that prejudices somebody that has less money. And I think that's pretty pervasive across the board, but certainly in domestic violence cases, I've seen quite a few times the state's attorney on the morning of the trial say, we're going to do what's called a nollie pros. We're not going to go forward. We don't have enough evidence, or they'll say that their witness didn't show up and so they don't want to go forward. And really what they're saying is, I never had a case to begin with. Well, then why'd you bring it? Because you were hoping somebody would roll over?
Right. Yeah, that's terrible. That is disgusting. Yeah. What do you and that stems from the prosecution's office, right? They get to decide whether they want to go ahead and prosecute a case. And they have so much discretion and latitude, right? They can choose to prosecute a case, even if the evidence is flimsy and the fact pattern is dubious, and right. And you just explained how in some cases they do get convictions, right? Because somebody cannot afford to hire a quality attorney. What are your thoughts on how potentially that could be solved at the prosecution's office?
You know, it's completely unrealistic, and I realize this will never happen. But if there weren't immunity for the state, if you could make the state or the prosecutor's office responsible for the attorney's fees of the defendant when you bring a frivolous case, these would stop real fast. But you can't. You can't hit the state with in certain circumstances, maybe malicious prosecution, sure. But in an ordinary case where somebody just doesn't have the resources to file a lawsuit against the municipality that brought the charges to begin with, the court that's hearing it is just going to let them withdraw their case, and good luck trying to hit them with fees or sanctions. But if that were easier, if there were a mechanism in place like when you have private parties, and you can prove an untrue statement, or you can prove that there was no merit to begin with, and then the state's attorney's office has to reimburse the attorney's fees, I think that would correct this really quickly.
I think you're right. Why do you think it's unrealistic?
You know, there's protections for government authorities. There's immunities that are baked into the system, sometimes for good reason. You don't want the prosecution to be reluctant to bring cases where there is merit just because they're afraid of being sued. And so, you know, there's a qualified immunity, there's immunity for judges, there's immunity for prosecutors. And short of something like a malicious prosecution case, there isn't a good avenue to seek reimbursement of attorney's fees. And I think there's a resistance to change as an institution. I think, you know, changing the dynamic or changing the landscape such that you're on equal footing with the prosecution is asking a lot of a change resistant system.
Yeah, you're right. The one concern you brought up, which I would have to disagree with, I don't think it's a realistic concern, right? You said, but I understand that's the overall kind of the philosophy that exists, right? That you would be that people would probably, that the system would be reluctant to change in that direction because they'd be concerned that a prosecutor would be reluctant to bring a case you know, that's meritorious because of his fear of being, you know, being held liable, right? If for whatever reason the case falls apart. But the reason I'm saying I disagree with that being a realistic concern is because fundamentally, if it's a legitimate case, then the risk is slim, right? It's right. If it's a legitimate case, then the risk should be minimal. And if the evidence is questionable, then they have the resources to do some further investigation and either prop up the case, right, and make it stronger, right, corroborate the allegations, or come to the conclusion that it's not a legitimate case. So I think, I mean, I don't know if you agree or disagree, but it's not a legitimate concern. I think because they have the resources to investigate the case before pursuing it, right? It's not like it's a party.
So you see a similar issue in play when it comes to police. Police now are very reluctant to chase. They're very reluctant to try to arrest somebody if it's not something major because they're being sued left and right. So like in Chicago particularly, which is a very violent and dangerous place these days, a police officer could be standing on the corner watching a crime take place and they don't want to get involved. They don't want to chase the person and try to arrest them. And the reason is they're getting sued. They shouldn't be afraid to enforce the law. They shouldn't be afraid to do their job. But they are, and they don't want to draw their weapon, and they don't want to, you know, accidentally fire and they don't want to arrest someone they shouldn't have arrested. And so it's just easier for them to say, this is going to be a problem for me. I don't want to get involved. And it's similar, I think the state's attorney's office, if we start to shift fees onto them for prosecution of cases that are a little dubious, I think that there's a possibility that they are going to be reluctant to bring cases. And then some people that really should be facing charges might not because they're reluctant to bring the case.
That's interesting. Yeah, that's interesting. And that has to do with more with the emotional, the human component of things, not necessarily factually what's there, but right, because if they're witnessing a crime, then if they're witnessing a crime is a crime, right? If somebody's getting beat up, or if they're breaking into a store and running out with goods that don't belong to them, a crime is a crime. But what you're addressing is the human kind of component, the psyche part of it, where they're just going to be less inclined, right, to move forward, even if they have a legitimate basis because of the fear. Something you touched. Go ahead.
No, I was just going to say you're right.
Yeah, and then there's something you touched on that I think is interesting, and I'm glad that it wasn't my plan, but you just talked about the immunities that exist. So as you know, I create some content, and one of the things that I talked about is that the difficulty of being able to hold judges accountable, or prosecutors. And I had somebody make a comment where they, and it must have been somebody who had a law degree, right? They cited the exact statute and code and rules or whatever, right? But the reality is, in theory, right, it's there. But right, if you have experience with the system, then you understand that it's incredibly difficult to hold, for example, a judge, right? Judge might have, like in Utah, they call them canons. And then they have obviously other rules, and to kind of hold them in place, to try to guardrails or whatever you want to call them. But it's incredibly difficult and expensive, a lengthy process to be able to hold somebody accountable in those types of positions, which you pointed out. So I thank you for making that point. I think that's, yeah, I mean, there's theory, and then there's practicality, right? What that actually happens.
It's similar in Illinois to what you're describing, the canon. So, we have the Judicial Inquiry Board that investigates complaints about judges and when a judge does something they shouldn't do, and they don't go very far very often. They're deferential to the judge. They get what's called a beef. They get beefs all the time from just unhappy litigants. And so, it's hard to sort out the meritorious complaints through the noise of tons and tons of cases where somebody's just upset about the outcome. If you don't like the ruling, that doesn't necessarily mean the judge did something unethical, but there are cases where the judge did something unethical, and it's hard to weed them out.
Right. So I have one final tough question, right? And then we'll get to the easy questions. But I'd love to ask you what your opinion is, and what you, as far as what you think the Me Too movement, right? That started a few years back, right? What do you think that has done for your area of practice? I know we've talked already about some of the difficulties and complexities and the inequalities that exist within that structure. But I'm just curious to know what your opinion is as far as what that Me Too movement has done to your area of profession, and what you see there.
I think the unintended consequence of it is that the pendulum has swung in the wrong direction. And that was bound to happen. And there are obviously cases where people have done something wrong, but then there are cases where people are jumping on a bandwagon and accusing people of doing something wrong. And the mere accusation of wrongdoing nowadays is enough to ruin someone's career. And, what I see in practice is lawyers that would once offer mentoring to law students or to young associates. They don't want to do it anymore. They don't want to be accused of, something untoward towards the law student, towards the clerk, towards the associate. So they say hands off. And so now the unintended consequence is these people aren't being mentored. They're not being, there's no like apprenticeships anymore, because you're just afraid that you're going to be accused of doing something wrong. And for every one bad actor that was doing something wrong, there's probably 1,000 that were not. And so people are losing out on those opportunities to be mentored by, good lawyers. And I think it's an unfortunate unintended consequence. Once upon a time, not too long ago, you'd have a close working relationship with a partner in a law firm, and you'd go out to lunch after a trial, or you'd go out to dinner and you'd talk about the case. And now it's just, I don't want anything to do with that, or like I need a witness in the room to dispel any accusations that I did something improper. And it's bad for everybody. It's bad for the lawyer because they can be accused of something and it tanks their career. And it's bad for the law student or the associates that are losing out on mentoring and losing out on, being able to learn outside of the office because of something they didn't do. And so I think there was a time and a place, and a lot of these complaints were well grounded, but many were not. And the pendulum swinging the other direction has been bad for everyone.
Yeah, cool. Well put. Like to finish up with some easy questions, just to dive deeper into, to you. What do you do every day? If you could share with us, what do you do every day that makes you happy?
Exercise makes me happy. I try to start every day off with that. It's a great stress release. The job can be stressful. It's at least an hour a day that I can put the phone down, put the computer down, and just focus on me. So I like that. And I like to be able to play around with the kids when I get home from work. That hour or two before bedtime of just being able to roll around with them on the floor and let them climb all over me and hit me with pillows is something I take a lot of joy from. And our kids grow up fast, so I try to really maximize that as best I can.
That's cool. That's awesome. Where do you see yourself in 10 years?
Probably sitting in the same chair that I'm sitting in right now, with more gray hair and older kids. Um, I like what I do, so I don't imagine doing something different. Maybe higher stakes, maybe more clients, but maybe not. I do like where I am, so I would imagine I'll be in a similar position.
Um, Here's a fun but tough question in a sense, right? If you've never thought about it, but if today was your last day, what three things would you like people to know about you and what you stood for?
I would like the takeaway to be that I was a good dad to my kids. Um, Hopefully that I was a good husband to my wife, and that I was a good lawyer to my clients, that I was a zealous advocate for them, and that they appreciated that about me.
Nice. Awesome. And Jonathan, so this concludes our podcast. Thank you again. I'd love to ask you if anybody would like to get a hold of you, how can they reach you? Can you give us kind of your handles and different ways that people can get a hold of you?
Yeah, as of quite recently, I'm on Instagram and Twitter and YouTube. And my handle on all those is Steele Fam Law. Otherwise, the firm's website, biermanlaw.com, gives you some contact information for me. And, I'm always available. I live on my phone, so I'm pretty accessible.
Nice. Awesome. Well, thank you again, Jonathan. I appreciate it. Thank you. It's been a pleasure. And I think this is going to be great for our listeners.
Thank you. It was a pleasure to be with you.
Thanks.